Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning. Welcome, everyone. I'm Judah Strafchinsky, Director of Practice Pro, LAWPRO's Claims Prevention and Risk Management Program. I'm speaking to you from Toronto, which is where the offices of LAWPRO and the Toronto Lawyers Association are located. I acknowledge respectfully that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now the home to many First Nation, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. As this meeting is virtual, we're not all gathered in the same space. We're not all in Toronto today. And so for many of you, this land acknowledgement is not for the territory you're on. And if that's your situation, we invite you to take some time to learn about and acknowledge the traditional territory and treaty lands you're on. As a resource, please visit native.lands.ca to search a location to find the appropriate territorial acknowledgement. You can find that under their resources tab, or you can contact a Friendship Center for guidance. I'd like to recognize the long history of all First Nations in Ontario and the Métis and Inuit peoples. We thank First Nations people who lived and live in these lands for sharing them with us in peace. Thank you for joining us for today's CPD event, Tips for Advocates, which LAWPRO is presenting in partnership with Toronto Lawyers Association. Today, we've got about an hour and a half together, and we're going to divide it into three main thematic areas of discussion. So first, we're going to review top areas where advocates have reported claims to us. Then, as our second big piece, we're going to review the different areas that hit us hardest, the biggest one being limitation periods and deadlines. So our second big theme will be on focusing down onto that area, and we'll leave you with lots of practical tips to reduce your risk around that silent killer. And finally, we're going to spend a few minutes exploring pandemic shifts in practice management and where things are likely to go next. We'll leave you with some resources to help move you along to whatever becomes your next normal. We've also put together written resources for today's program. They're available both at practicepro.ca/CPD. And for those of you who are here today live with us, we're going to be putting it into the program chat, so you can click from there. If you go to download them from the website, just know that they are under the supporting material link. The speakers with us here are amazing. I'm honored to be with them. They bring incredible knowledge and expertise from all sorts of different aspects of advocacy. I'm going to let them introduce themselves quickly, but just so you know, each speaker is, their bios are in the program resources. And so we can learn more about these wonderful people in the program materials. So let's kick it off. We're going to start with sort of a refresher on risks and the biggest claims risks faced by advocates. And what I'm going to do is first, I'm going to share a few slides that show the data that LAWPRO has collected. And so then I'm going to invite different people from different areas of practice to speak to them. So let me just get these screens on for everyone. And what you'll see, and I'll start with this, is that you have for the last decade, these are the types of issues that come into LAWPRO across all areas of practice. And so what we do as the mandatory insurer for lawyers is we actually can see the entire bird's eye view of all the areas of risk for lawyers in private practice in the profession. And when a claim comes in, whether it's one with merit or without, we code them. And we've got some of our wonderful claims counsel here who do that coding, where they see the file and say, what's the biggest issue here? And they will let us know. And they go into drill down about this as well. And we keep these records and monitor them over time. And then we develop these pie charts to help people know. I lovingly call them the wheel of misfortune. But if you look at this wheel of misfortune, what you can see is that communication with your client is a significant issue across the board. Inadequate investigation, not digging deep enough into files, is number two universally. Time management is third place across all areas of practice. And then actual mistakes in law, making a mistake in the interpretation of the law, giving bad legal advice, that's number four. So it turns out that for many areas of practice, although you can make a mistake in your advice, it's usually the service delivery of that advice that's the biggest problem around communicating or digging deeper or managing your time. Those are the bigger pieces. And so, lawyers, paralegals, your staff, you're all collectively delivering legal services, a professional service. The professional judgment call is usually only the fourth biggest risk. It's the services part in delivering professional services that are the top risks. Now, in litigation, though, that profile changes a little bit. So, Lucas, maybe you can take us through some of the civil litigation claims and how the wheel changes for litigators.
Well, the wheel for litigation claims really illustrates what Judah was just saying, which is really it's the service part of what we do that where we run into problems. So we can see here that by far the greatest number of claims arise in the context of time management, and included in that are issues like missing limitation periods, failing to diarize milestones or steps in litigation, not moving litigation along in a timely way, or resulting in potential dismissal of claims for delay. We see also the next largest category is communications, and that relates to managing client expectations, ensuring that risks and costs are communicated, ensuring that advice is properly understood by the client, and that instructions are properly understood. So those are the two largest categories, and then it's only after that do we get to issues like inadequate investigation, and then errors relating to law or clerical errors or other types of errors. But what we see here is definitely that it's a service part of what we do that trips us up the most.
Okay, thanks, Lucas. And then if we move to defense, it's interesting, and I'll just mention this because you can see that communication goes back into the top of the bucket with time management. And you might be curious, how can defense litigators have an issue with time management? And partly, and we'll talk about some of these errors in more detail down the road, but part of this is about just losing track of time about some of the rights that your client might have. And so there might be a court order timeline and you lose track of things, or it may be that an action, your client gets sued, but it drags for a while. And so you take your foot off the gas, and it's only on the eve of going into discoveries that you think, oh, wait a minute, maybe I should have third-partied somebody. But by that point, you're out of time. And so the time management's still a big piece here. And again, inadequate investigation, time management, communication, when you combine all three of those, well over half of all the mistakes. And worth noting if you're on defense, not offense. So for family law claims, we just ran a program, and so we're not going to spend much time here, but you can see error of law ticks upward, and that's because family law is very complicated with federal and provincial jurisdiction at issue, and all sorts of different procedural steps that need to be taken and intersecting areas of law. But it's client management that's really at the core of this one. And to learn more about what we're seeing in family law, I'd encourage you to just go and watch the CPD that we ran last month. That's available for replay on our Practice Pro CPD website. Sean, over to you about employment claims. And Sean's got a bit of a mask on right now. I'm not sure if you can see him now that the charts are here, but if you're having troubles, he's going to do his best to speak up.
All right, so good morning. My name is Sean Bodden. I am masked and joining you from Algonquin College with 40 some odd of my new best friends and students. So thank you for joining me as I am holding a bit of a hostage situation here on my end. So the reason that I'm speaking to you from Algonquin College is that I teach employment law. It's the students' first class today. And what I wanted them to attend for was to demonstrate where things can go wrong. And in employment law, the wheel of misfortune, as we would call it, skews heavily more on the error of law side. And where this plays out between error of law and inadequate investigation is primarily in respect of the fact that there are myriad different places where one can read their employment review. It's not a single source. There are different tribunals, different statutes. It is both federally and provincially regulated, although not both. And so the issue in employment law especially is knowing where one is to put their case. And the limitation issues are different. There are different limitation periods applicable in the employment world than in the general civil world. And so we'll speak a bit to that, but one needs to be mindful that when, quote, an employment case walks through the door or something that happened at work, that it might not simply be as straightforward as one statute. There are likely overlapping, intersecting areas. And so, yes, we still have issue on communication, obviously, but disproportionately to some of what we've ever seen, in other cases, we have errors of law and inadequate investigation, which likely speaks to the fact that it's such a nuanced, complicated, interwoven world, which, you know, I've now brought the ongoing hostages to learn about and learn about how the wheel of misfortune can affect them as we go through.
And, you know, we're going to spend a lot of the day talking about the client side, which will impact for employment lawyers. Obviously, whether you're counseling employers or employees, things can get pretty supercharged in this area because it really is people law. But when we talk error of law, I know Sean hasn't slept since like March 2020, keeping up with all the different changes that have happened, be it the different government programs that may or may not impact on duties and all sorts of other changes that we're seeing. And today's a big day, Sean, right? Like there's a case. Do you want to speak about briefly what's about to go down at the Court of Appeal for Ontario?
Yeah, so the Court of Appeal for Ontario today releases its decision in Taylor and Hanley, which is a COVID infectious disease emergency leave decision, in which the Court of Appeal will hopefully opine on the question of whether the regulation made at the start of the pandemic saying that employees sent home on account of the pandemic, they're not constructively dismissed, whether that regulation applies to the common law or applies only for the purposes of the ESA. When it was first tested, two Superior Court judges went in polar opposite decisions. And so finally today we have the Court of Appeal opining on whether or not regulation making can ice the common law, and that impact on areas outside of employment law could well be quite substantial. So key state employment law, you know, probably about 1 million constructive dismissal claims, to no small exaggeration, waiting in the wings, depending on how today goes. So, you know, no big deal.
No big deal, just fundamental changes on employment law. Well, thanks, Sean, and a really important day in that respect. So we'll all stay tuned and read that case to avoid the error of law. Immigration is another area where we see interesting claims, and we're thrilled to have Jackie with us, who's a leading lawyer in this area. Jackie.
Thanks, Judah. So you'll see with immigration claims, again, it's primarily service delivery, with communications being at number one. So communications include things like when you're doing a basis of claim for your client, not clearly communicating what is required, not having it properly translated, either a basis of claim or anything in the immigration law context. You're often dealing with interpreters, making sure that the client understands, you know, what is going on, that you provide them with copies of all of their materials, and that you listen to their personal stories and don't just use boilerplate narratives or boilerplate information in other areas, because everyone is distinct, and that's important to capture. With regards to the time management piece, although we don't have a lot of limitations periods in immigration law, there are a lot of deadlines. And so obviously making sure you're staying up to date and not missing those deadlines. But it's not just the hard deadlines that lead to problems, it's also the softer ones. So a lot of the claims that LAWPRO sees have to do with where a counsel has submitted an application that requires an update, but hasn't been timely in providing that update to the decision maker. And a negative decision gets rendered. And even though the client has provided the lawyer with all the documentation, the lawyer's failure to promptly update that application can then result in some problems. So time management, obviously in any area, but especially in immigration law, quite important. With regards to the error of law, it's also a substantial piece, although somewhat less than communication. Here, again, like employment law, constantly changing. I feel like immigration law might win the prize, given the COVID pandemic and border regulations changing pretty much every couple months over the last 2 years, and affecting basically every practice area in immigration law. And so making sure, that you're up to date, that you're following the correct policy, and also that you're aware of all of the different ways that your client is able to get to Canada. So, not advising a client on potential options that they have available to them can result in a claim being made against you down the road. And then the biggest area that I know LawPro sees are the ineffective assistance of counsel claims. And these are claims that are brought to the federal court where a client's new counsel is alleging that the previous counsel engaged in some sort of error that resulted in a negative determination. And so I know that, is a large number of claims that LawPro sees. And here just making sure that if, because the federal court's policy mandates that the new counsel reach out to you, if, new counsel reaches out to you, just make sure that you follow up with LawPro right away so they can get involved in the process early on. So I think, that's like in any area of law, there's a mixed bag, but it's just important to basically keep on top of things, I think, all the way through.
Thanks, Jackie. And then if you end up in with immigration claims, you're also probably going to end up meeting with one of our LawPro claims counsel, Katie James, who handles a lot of those. So Katie, maybe I can turn to you just quickly to ask you a little bit about what you see. And forgive me, I don't have the slides, but for criminal law, you can lead us through that area as well.
Yeah, good morning, Judah. So traditionally, the areas of immigration and criminal were not high reporting claims at LawPro. And I'd say in the last 5 years or so, we've seen a significant increase in claims being reported in these two areas. So I think it's important to note to the practitioners out there that just because you practice in criminal immigration, you're not necessarily immune to these sort of allegations or assertions. So you should definitely report to LawPro when you're in doubt of any potential issues in your file. So unfortunately, the wheel of misfortune for criminal and immigration lawyers has certainly started to spin quite quickly from our perspective. I can say, as Jackie had mentioned just earlier, that ineffective assistance of counsel claims where the protocol is invoked, both in criminal and immigration, are certainly at the top of our list. We're seeing them regularly and they're coming in frequently. And I alert you to reporting them in a timely manner. I encourage our insureds, if they are met with any subsequent counsel asking questions about what they did in an underlying action or procedure, that prior to answering those questions, they should likely just report that to LawPro, because it's more often than not that's the first sign that an allegation will be coming down the pipe. And the timelines, as Jackie had mentioned, are very strict. So the earlier LawPro can get in and help you in responding, the better. Outside of ineffective assistance of counsel, we see lots of other allegations made against criminal lawyers. For example, we see examples of insureds being accused of not telling their clients various options that are available, including the right to testify or procedural steps they could have been aware of, like re-elections. Those are often caught up and are subject to timelines within the criminal code, so be careful with those. We often find that clients complain that they weren't communicated with, they didn't understand the process, or they were pressured to enter a guilty plea under duress. Those sort of allegations are coming towards us. We see a lot of allegations as well about impact on sentencing with respect to immigration. So we see a lot of cross references in immigration and criminal law. So it's very important, again, to make sure that if you're a criminal practitioner and you don't have obviously any immigration background or don't practice in that area, to refer your client out to an immigration practitioner to get an opinion prior to any sentence or maybe procedural step being taken in a criminal action. So those are my tips with respect to reporting and looking out for potential claims in those two areas.
Well, thanks, Katie, and thanks everyone for kicking us off with, just knowing our risks, knowing where they start is a really important foundational aspect to practicing effectively and making sure that we have our risks in mind so that we can reduce them. We've given you the most recent slides right now. There was a question about where can I find these, and in the program materials, we don't have those wheels that are up to 2021, but we do have the tip sheets for each of these areas of advocacy, whether it's civil litigation, employment, criminal, family, wherever you practice. We've reproduced our 2-page tip sheets in the materials, and those have wheels that are maybe 1 or 2 years behind what we just showed you, but really there has not been that big of a change in any of the areas from the most recent data that we wanted to share this morning. And so if you consult the program materials, you can see all of the areas that apply to your specific practice niches, and then you can learn about those and see some quick tips in those 2-pagers as well to get you going. But there is one thing that's pretty universal, and whether it's the small deadline that does creep up for the immigration lawyer, or some of the issues that a criminal defense lawyer will have to move a file forward, or the civil litigator who's got all sorts of stoplights, green lights, and everything in between, but they need to get from A to B efficiently. Time management is really a killer. It really is where a lot of lawyers, regardless of year of call, regardless of practice structure, regardless of firm size, regardless of geography, this is one that hits universally. LawPro, because we see all the claims, we've developed amazing expertise. Many of you may know Deborah Rolfe, who authored one of the textbooks around limitations, and I see that she's joined us to watch. So hi, Deborah. And she's mentored many a protege. One of them is Jordan Nichols, and he's here with us today. We've also included Jordan's paper in the materials. And at the end of the materials, towards the end of the resources, we link to many other of the Practice Pro limitation and notice period resources as well. I'd encourage you to look at all of them. But Jordan, let's start about what we see it, and maybe tell people about what you do all day, because Jordan is like one of the people who's got the closest. He's really got the pulse of what's going on because of his role at LawPro. So over to you, Jordan.
Thanks, Judah. So I am a unit director and counsel at LawPro. My focus is on dealing with potential claims and claims before a lawyer gets sued. And so we're focused on trying to put out fires and repair matters before the problem gets out of control. I personally deal with a lot of litigation matters with a lot of focus on limitation period issues and litigation repairs in general. In terms of what we're seeing, in terms of how lawyers get tripped up by limitation periods, this is not something that can be easily summarized in a short amount of time. One of the real problems and reasons that limitation periods are so dangerous is because there are just a huge number of ways that lawyers can get tripped up by them. And I still see new scenarios now that I've never seen before involving limitation periods. So rather than try and give any kind of an exhaustive list here, I'm just going to try and touch on some of the many key issues that we see. So one of the more common situations we see is simply mistakes arising from mistakes or misunderstandings regarding facts. And this can be mistakes regarding the relevant dates. It can be simply a failure to appreciate that something happened with respect to the client that may have resulted in the client discovering the claim earlier than the lawyer appreciated. It could involve a mistake regarding the parties in question, so who it is that should be sued, or similarly, we see sometimes, especially with slip and fall claims, but also potentially other claims, we see mistakes about geographical issues. So with a slip and fall, you may mistakenly believe that the fall happened on municipal property when in fact it happened on private lands, and that can result in suing the wrong party. The flip side of that, the other type of error that we sometimes see, or another type of error, is mistakes regarding the law. And so with limitation periods, the law is quite developed. There's a lot of case law dealing with very specific situations. And if lawyers aren't alert to that case law, it's just so easy to slip up. And we see so many examples of this. I've got some examples in the paper that's in the materials, but I'll give one example just to help illustrate the point. And that is with respect to claims against insurers for coverage. So many lawyers will assume that a claim against an insurer for coverage starts to run when the insurer denies coverage. And that is in fact true in some cases, but the law on this issue is sort of all over the place. And there are multiple Court of Appeal decisions that actually indicate that, at least in some cases, the limitation period for a claim for coverage actually starts to run from the moment, or from, actually they say the day after, for some reason, the insured seeks coverage. So if you don't know that and you're relying on the idea that it runs from when there's a denial of coverage, you can get into trouble. Another example that we see is failing to warn about limitation periods in situations where a lawyer is aware of a claim or consulted regarding a claim, but doesn't end up being retained to handle that claim. We see, obviously, the obvious one that people tend to think about, I think, is the failure to diarize or misdiarizing of deadlines. We see one issue is where lawyers don't look at a file quickly enough upon being retained, and therefore don't realize that matter that they've just been retained on has a limitation period that's about to expire. And the reality is, unfortunately, as a litigator, every file that comes in the door is potentially a ticking time bomb. And as busy as you are, you got to take a look at that, unfortunately, fairly quickly, or you are taking a real chance. We also see situations where lawyers get so caught up in negotiation of matters that they lose track of the fact that there's a limitation period running. And then one other one I want to talk about, and really, these are just the tip of the iceberg. I deal with a lot of other scenarios in the article that I've written that you can feel free to take a look at. But one other one I want to talk about in a little bit of detail is that we see errors involving lawyers overlooking some of the less common limitation periods. This problem arises to some extent from the fact that the vast majority of claims in Ontario are subject really only, or really the only issue that could come up on them is that they could be statute barred by way of the standard 2-year limitation period in Ontario. And so lawyers can go years and years without seeing any other limitation period issues beyond issues relating to the 2-year limitation period. And so it can be really easy for lawyers to get lulled into a false sense of security and lose track of the fact that there are other limitation periods out there. And there's actually about 45 different statutes in Ontario that contain limitation periods. Some of those statutes are really obscure, some to the point where I probably have never seen any problems arising from them. But there are some that that we do see somewhat regularly. And I wanted to just point those ones out because they are the most dangerous ones. So in terms of what we're seeing somewhat regularly, one limitation period that tends to trip up lawyers is Section 38 of the Trustee Act. This is a limitation period that applies to many claims, not all claims, but many claims, either by or against the estates of deceased people. And at first glance, one might think it shouldn't be a big problem, this limitation period, because it is a 2-year limitation period, just like the standard Ontario limitation period. But what makes this limitation period very dangerous is that it is not subject to discoverability. It runs from the date of the death of the deceased person. And once you hit the 2-year mark after that date, you potentially have a problem. Another one that we see come up from time to time is Section 259.1 of the Insurance Act. This limitation period is a 1-year limitation period that applies to certain property loss claims arising from motor vehicle accidents. We also see claims arising from Section 61 of the Succession Law Reform Act, which applies to claims for dependents relief. There are some Family Law Act limitation periods that anyone dealing with Family Act should be aware of, dealing with claims for equalization. And another big one that we are now seeing over the last few years a fair amount is situations where lawyers are missing the 15-year ultimate limitation period set out in the Limitations Act 2002. Although the ultimate limitation period is 15 years, and so you wouldn't think it would come up that often, what makes it dangerous is, just like the Trustee Act limitation period, discoverability does not apply. So potentially you could be dealing with a situation where your client has just learned of a claim for the first time, only a few weeks earlier, and your focus as a lawyer potentially would be on the fact the client just learned, and you might think you have all the time in the world. But if the claim arises from something that happened 15 years or more earlier, then in fact, the limitation period could be about to expire, and it just may not be on your radar. One other source of limitation periods that is really dangerous is limitation periods set out in contracts. We see a lot of claims involving lawyers who overlook these, and you can see why. You potentially could have a 500-page contract, and in that contract, there could be a single line in it somewhere setting out a limitation period. And if a lawyer doesn't see that, then they can miss it. I would suggest that lawyers be on alert anytime they're dealing with a claim arising from a contract to these contractual limitation periods, but in particular, be on the lookout when you're dealing with an insurance policy, a retainer letter involving a professional firm, and sometimes some other standard form contracts. That's where I tend to see those limitation periods. There are sometimes ways around these problems with contractual limitation periods, but sometimes there are, sometimes there aren't. So better to just be safe and check for them.
Well, thanks, Jordan. I want to be clear about some of this, okay? What Jordan just gave us was like every single pitfall imaginable across different practice areas. That's like, if you're like, whether you're a law student or in Sean's paralegal class, I want you to know that there is no single fact pattern that could cover all of that all at once. Okay, that's like beyond the end of Mario Brothers, where you're trying to like get to that like final monster to free the person at the end. Like it's like level 19 million. It's not going to be all of that all at once, but there are going to be lots of things happening. you know, even a level 1 Mario player still has multiple things to be considering as they're moving forward. And that's how you should be thinking about the limitation periods as well. There are going to be many moving parts, starting with client intake, getting the right information, and analyzing that and moving that forward. This type of synthesis is at the core of professionalism. The educators who study how people learn and what professions need to do, lawyers and paralegals, you're taking very complex pieces acquired through different skills, through oral interviews, through document review, through knowledge, through checking that knowledge with books and resources and trying to put it together. So this is a challenge, make no mistake, but what Jordan just threw at you was like the entire, well, not the entire, we've seen it all, but that was almost including the kitchen sink. Let's put it that way. So the good news is we do have some tips today. We have sort of a top 10 that we're gonna walk you through with some really helpful practical tips that hopefully will help you both in the immediate and as you build up your skill sets to take on the more complex levels as you gain your way through the legal system. So Katie, maybe I'll start with you.
Great, thanks, Judah. Just circling back to my earlier comments about ineffective assistance counsel too, I just wanted to alert everyone on the call today and listening that traditionally I have seen them in immigration and criminal files, but I can tell you that recently I've had a number of them come in a civil context. So for example, I've had ones where an allegation has been made against insured for not varying an order, and they've alleged ineffective assistance, or that they didn't clearly take a certain step in a civil proceeding, and therefore now being investigated, or allegations are being made by subsequent counsel against the insured. So while traditionally immigration and criminal have been the forefront of ineffective, I can tell you that the civil practitioners out there should be alive to the fact that we are now seeing those sort of assertions being made by civil subsequent counsel or appellate counsel. Turning to the tips, Jordan just went over all the limitation period issues we see. So I encourage everyone on the panel today to take a look at Jordan's article and read through it, as well as the materials that are available on Practice Pro. There's a wealth of information and current articles that we deal with. You can also sign up for Avoid a Claim. And those alerts come out, I believe, on Tuesdays, right, Judah, with respect to Avoid a Claim?
They come out, actually, if you just subscribe, they come to you, and they're not just weekly, it's whenever there's a key development or a key update on the site.
So I encourage you to sign up for those as well. And Jordan had mentioned a couple of limitation factors, and I just wanted to mention it's important when you get a new file and you're doing a personal injury file or any file in particular, but when you do the initial intake, I've noticed a lot of files come across my desk where the insured takes it for granted that the information the client has given you is accurate. So a lot of times they'll say, well, I had a car accident on this date, or I slipped and fell on this date. And the insured would sit down their file and takes it for granted that that's actually the date the occurrence occurred. Meanwhile, the client has brought in police records, or you're able to access police records as to the accident, or ambulance records or hospital records. And it turns out, lo and behold, the accident actually occurred 4 days before, and you've misdiarized and therefore missed the limitation period. So those are key examples of, it's important to have that communication right at the get-go, and when you're retained, to make sure and fact check that the client's information is actually accurate. So again, I just encourage you to go to Practice Pro, look at our materials, and review your files, and keep a close eye on potential dates that your clients tell you.
So, I mean, tip number one, the key piece, I think it's really important to given Katie's expertise and what we're seeing, to remind people that we are seeing different claims arising as we go. But that tip, I mean, to bring it just a little directly back to the program materials, I wanted to tell you that the resources that relate to the limitation periods are also in the program resources. So you can start there if you want and click on the links to the limitation and time management resources as well. Very, very helpful, though, to know where things are heading right now. Jordan, over to you.
Okay, so this will overlap a little bit with what Katie just talked about, but I just want to talk about how to avoid these situations if you can, where you get the facts wrong and that leads to a missed limitation period. And so one of the things that's really I find interesting and noteworthy is that so often when we get a claim report from a lawyer who has missed a limitation period, so often that lawyer we see realized for the first time that they have a problem during examinations for discovery. And one thing that makes that even more interesting is that a lot of the times they learn about the oversight that they've had, not from the examination for discovery of the opposing side, but actually from the discovery of their own client. And what that suggests to me is that a lot of times the information that the lawyer needed in order to avoid the error was information that could have been obtained from the client at the outset, and that for whatever reason it wasn't. And so how do you avoid these problems? It is easier said than done. Sometimes it's hard to get information out of a client, or clients can give you the incorrect information, but there are certain steps that you can try to take to avoid these problems. So first off, it's a good practice to try to do a thorough factual investigation at the outset of a retainer. I know some lawyers will take the view that, you know what, they'll learn the file as they go and they'll learn it through the examinations for discovery, but that approach is exactly how you get into trouble. So sit down with the client at the outset, have a good discussion about the facts. It can help to put documents in front of your client, basically almost do a cross-examination of your client at the outset. Try to make sure that what the client's telling you is consistent with what's in the documents. Another really useful technique is that if there's an issue about where something happened, it's very useful to get a map, put a map in front of your client, or get an aerial photo from Google Maps and put it in front of your client and have your client mark off on that map exactly where the problem happened, and then keep that, because it's useful to have that for your own file, that your client identified the location on a map. It's also important to collect up and request any documentation at an early stage that your client doesn't have that you might need, whether it be medical records or whatever. Don't wait. Ask for that information and review it. And then, you know, that would include even just doing corporate searches to make sure that you know who the right party is that you're suing, or even who the right plaintiff is, because sometimes you need to do a corporate search to know who you're acting for. The other thing that I would suggest is to put, when you're relying heavily on factual information provided by your client, I think it's a good practice to send the client a letter setting out the information that the client has told you about, telling the client that you're going to be relying on that and that it's really important, and letting the client know that if for whatever reason that information is incorrect, that you need the client to let you know as soon as the client can, and you need the client to dig down and make sure that the information is right. Anyway, that's it for that tip, and we're on to the next tip.
All right, so I think that's me. So one of the things I've been doing during my class come hostage taking right now is sort of supplementing for the students some things that Jordan has been talking about vis-a-vis wilderness and first assignment, which is on client intake and client reporting. And so for their benefit, but sort of pick up on what Jordan's saying, you know, it's very important to confirm back to people you've just met what they told you. For two reasons. One, to get a thorough understanding, but two, to the extent that they were not entirely truthful with you, it will help you down the road when you do things in accordance with what they told you. And so I confirm you told me X. If that's not true, advise me now. And so that's good practice for people who are going to retain you. The other thing to be mindful of is that we're not all, not all frogs are going to turn into princes. We are going to meet people who are not going to retain us, but who will have told us things or given us documents. People will share information with you and then not want to meet the terms of your retainer. And in those cases, it is incumbent on you as the professional to send documentation to that individual confirming, first and foremost, you have not retained me. I am not your legal representative. And accordingly, I am not doing anything to advance your interest. Do not rely on me to assist you. And this may shock those of you new to the profession, which people in front of me are, is that people will come and tell you things and assume that you're their lawyer and that you're taking care of this thing, and they won't call you for years. And then they will call you back and say, hey, did I win? Where's my money? And my students laugh, but Judah, Jordan, I don't think this happens, right? People come meet with you once, tell you their tale of woe, and then call you 2 years later and say, how much money did I get? And they'll say, I have no idea who you are, right? I don't remember you. And this happens. And so where that happens, you need to send them a letter. No, you're not going to get paid. No, it doesn't help your billable hours, but you need to send them a letter that says, I'm not your legal representative. I am not doing anything to advance your case. And it would be prudent, if you know it, to opine on what the limitation date is by when they need to take steps. I.e., based on what you have told me, I believe that you have until X date, December 31st, 2023, to start a claim. The problem and the concern with this is be damn sure you're right in what you tell them that date is, and be mindful of all the myriad different limitation periods that apply, because there are some short ones in the employment law realm, especially in the WSIB world, in the workers' compensation world. Timelines are tight. In the human rights world, timelines are tight. And so, it's possible that you could advise someone who didn't retain you, who didn't pay you, you could give them faulty advice saying, oh, you have 2 years from when you got let go. Or sorry, from when the end of your notice period ended to commence a wrongful dismissal claim. You could give them you could give a non-client faulty advice that could come back and bite you. So definitely send a retainer letter. If you are not sure of what the applicable limitation date is, because they haven't given you enough information in your consult so far, tell them that. Right, Mom. My practice tip is to say there is a limitation period. You have not provided me enough information at this time for me to opine upon that. You should go speak to another lawyer to get that information. Time is ticking, off you go. But you got to advise them of that, because the alternative, to a lot of my class, is people are going to call you, phantom clients. Phantom clients have freaked me out since I first heard of them. That there is someone out there that I met 15 years ago who thinks I am diligently beavering away on their case that they told me about on a phone call, right? And they're going to call me up one day and say, where's my money? So, I've taught this for years, as I've told my students, they're going to learn this in the small claims classes. In their next class today, client interviewing, to send letters. Still, people will screw you, is what I told my students. If there's nothing else out there, they are ticking time bombs in this service profession.
So Sean, good point. And if you're gonna try to diffuse the bomb, there are two easy practice takeaways for your students and everyone. One is use written retainers, and you can confirm in those retainers what your understanding of the timelines are based on what you've heard. And we've got templates for retainers on Practice Pro's website, except for contingency fees, where we refer you to the mandatory forms that the Law Society prescribes. The second is we also, on that resource link at Practice Pro, have a template, not your advocate letter. And we do encourage you to let your phantom client, who is a non-client, who has consulted with you, know that there may be limitation issues affecting their claims. And so they should get on it ASAP. And you've got some template language for that in the resources. So definitely great point about whether you've been retained, and if not, how to cover yourself. Really important practice management to get in the habit of doing. Lucas.
The next tip relates to situations where you are engaged in settlement discussions and no action has been brought. And in those circumstances, you really have to keep your eye on limitation periods as they come up. These situations come up a lot in business disputes where the parties are talking and time slips by because materials going back and forth, financial information, the parties are reviewing the information, crunching the numbers, and it's easy to have just weeks and months slip by, and meanwhile the limitation period is coming up. We heard about just now about situations where you have cold calls and you want to write a no retainer letter. What I find in my practice dealing with business disputes is that you need to be careful when an existing client or a repeat client calls you up and says, we have something that's developing, an issue with a vendor or an issue with other parties, and we're working it out. We'll give you a call if there's a problem. And in those circumstances, it's easy to just say, yeah, well, give me a call if you've got a problem. But you don't want to leave the impression that you're actually watching over the matter. And in those circumstances, it's a really good idea to get at least minimum facts from the client just to ensure that you've got any sort of limitation periods pinned down, especially if you're not involved in the discussions themselves. Really, two strategies. If you're talking to the other side, there's no claim that's been commenced, time is slipping by, ask for a tolling agreement. The other side will give you a tolling agreement. If they're not willing to give you one, you should wonder why. If in doubt at all, start the action, and at least you've got an action that's been filed, and you don't have to worry about that particular clock running anymore.
Okay, I think I've got the next tip, and this tip is what I call the golden rule of avoiding limitation period problems. It's a very simple rule, but if you follow it, you can actually avoid the vast majority of limitation period issues. The tip is simply that if you are retained by a client who has a claim, issue the action, and issue the action quickly. I do appreciate there's practical considerations. I appreciate that lawyers are busy people, that you can't get on everything immediately. I appreciate that there needs to be, you do need to do a proper investigation of the facts, that you shouldn't just write a statement of claim so quickly that it contains lots of problems, and that's not what I'm suggesting you do. I'm not saying that you should be running out issuing an action the day you get a new retainer or even the week that a new retainer comes in. I'm simply suggesting that you not sit on it for months on end, and that in particular that you avoid situations, which I see all the time, where you wait for whatever reason until the last possible moment to sue. It's actually amazing how many of the claims that we see coming into LawPro involve that exact situation, where lawyers wait until the last possible moment to sue. And I don't understand why. It seems like that's just what some people do. And it can leave you in a real bind. And so I appreciate that there's probably some lawyers out there who are thinking, you know what, I know what I'm doing. I practice in a very specific area. I know it well. I can determine with great confidence when the limitation period is going to run out. And so what's the problem? Why can't I just diarize the matter and sue when just before the limitation period runs out? And my answer to that is simply that there's just so many things that can go wrong, things that you would never even expect that we see at LawPro. And so, just some examples of things that can go wrong when you wait to the last minute include, well, first off, some of the things we've already talked about. What if you've got the facts wrong? What if you've got miscalculated the timeline or did your discoverability analysis wrong? And on that point, I should mention that I discourage people from relying on discoverability at all if you can avoid it. There's just so many ways to get that analysis wrong. It's better to not rely on discoverability. Other examples of things that can go wrong would include, you could make a mistake in diarizing. What if one of the defendants has died and you don't know about it, and therefore the Trustee Act limitation period applies? What if you become ill right before the deadline for issuing the action? What if your assistant or your process server makes a mistake and the action doesn't get issued when it's supposed to? What if there's some technical issue with the statement of claim and the court rejects it and you haven't left yourself enough time? This is tip of the iceberg. We see so many different versions of this. It's just not worth the risk. And I will also mention that even if you do issue the action on time, leaving it to the last possible minute can still create problems, because you'll often find out shortly after you've issued the action, you'll often find out about certain problems, such as you may find out that certain amendments are needed, or you could find out that you've missed a notice requirement or something like that. And some of these things are much easier to cure if the limitation period has still not expired. So you want to leave yourself that time to fix any problems like that. Sometimes you do deal with situations where the client doesn't want you to sue right away for whatever reason. And Lucas has mentioned some strategies that would apply in that situation. You can ask for, or you can recommend that the client seek a tolling agreement, or you can simply issue the action and not serve it for 6 months. That's safer to do than to not issue, because even if you were to miss the deadline for service, that's usually not fatal. It's not ideal. You don't want to do that either, but it's better than missing a limitation period. The only other thing I'm going to mention quickly is when you do issue the action, it is a good practice to use John and Jane Doe placeholders liberally. I'm not suggesting you use it in all cases, but anytime you're dealing with a matter where there's reason to have concern that there may be other potential defendants out there, it is very useful to use those. They can get you out of some trouble down the road. In my article, I get into more detail on this and how to do it, because it can be tricky how you plead a John and Jane Doe claim, but I won't get into that now. That's it for that tip. I think I'm on for the next tip as well, so I'll move to that. The next tip deals with how to calculate the timelines, taking into account the COVID-19 suspension of limitation periods. Before I get into this, I'll just say again, my view is that you shouldn't rely on the COVID-19 suspension of limitation periods if you can avoid it. This is just my golden rule. Don't sit any longer than you have to. Issue the action. That said, if you do want to calculate time pertaining to the COVID-19 suspension period, the starting point is that there is a very good article on the practicepro.ca website dealing with that. It's called Tips for Calculating Limitations Deadlines Accounting for the COVID-19 Emergency Suspension Period. And that article really tells you everything you need to know. That said, I'll address it in a nutshell right now. Basically, the COVID-19 suspension resulted in the suspension of limitation periods and other deadlines for 182 days between March 16th, 2020 and September 14th, 2020. And so in a lot of cases, not every case, but in a lot of cases, all you're doing here is you are adding 182 days to the limitation period deadline. That's actually easier said than done. Counting days is tricky. And so there are websites that can help with that. One website is timeanddate.com. And you can just crunch in the dates and indicate you want 182 days added to that date, and it will tell you the date that matters. Be careful, because I know a lot of people have in their minds that 182 days is 6 months roughly, but be careful not to just count 6 months. You want to count by day. If you just add 6 months, you will in most cases be off by a little bit. The other thing to be careful about is that if you're dealing with a claim that would have started, where the limitation period would have started to run during the suspension period in 2020, but for the suspension, then you can't add 182 days. It's not going to be 82 days more that you have to sue. Rather, instead, in that scenario, the limitation period would start running on September 14th, 2020. So that's what that would be the date that matters. And that's it for that tip.
So the next tip is to make sure you use and follow a calendaring system. And this is not just for limitations periods, but also for other deadlines in your practice. And I mean, I think, most lawyers use one, but I think what's really important is to build in those buffers. And I know Jordan talked about this a little bit, as well as I think Lucas as well. You want to make sure that you build in things that can go wrong. So I will use the immigration context. We have disclosure deadlines for the Immigration Refugee Board. So obviously you want to put that in the calendar and make sure, you have a particular system to keep track of that. But you also want to build in buffers. Often we have to have documents translated. So you want to find out from the translator you're using, how long will it take them to translate documents? You want to build in a buffer for what happens if the translations come back wrong and you need to actually get something retranslated. And you want to build in a buffer of time where, if your client doesn't get something to you right at the exact minute that you need it, what you want to have enough time to be able to address that. So I would recommend not just putting in those, key timelines, but also the buffers that you need to make sure that you're not running into things that can arise in you missing a deadline. The other important part of this tip is to make sure that your staff is aware of how important it is to meet those timelines. Young lawyers in your firm who you might be working with, often it's not until you get, for example, I'll go back to the immigration board example. It's the first time you get that translation that's not properly translated that you have to build in the extra time for, where you realize like, oh shoot, I should have left time for that. So it's really helpful to impart on all of your staff how important it is, and to help them know what sorts of things that they need to be leaving time for, and what kind of errors might arise, and how long they should be building in those buffers. Because ultimately, obviously, you are the one who is responsible. And at the end of the day, if a claim is made, that's something that you have to take responsibility for. So use a calendar system, follow the calendar system, and build in your buffers. On to you, Lucas.
The next tip is kind of related, but it's use a file progress plan. And this is for not just timing, but also ensuring that you take certain steps. You can use the plan to diarize potential other limitation dates and deadlines. For example, limitation periods to add parties. For example, like claims for contribution indemnity. And on that point, it's important to remember. We all know that if you're defending an action and you want to start a contribution and indemnity claim, that you have 2 years from when your client was served with the statement of claim, but your third-party claim has to be commenced by that time. And so you need to start early and make sure that if you need leave, then go get leave. And even better yet, just commence it within the time period after your defense, so you don't even have to worry about leave. You want to make sure that dates relating to the Rule 48 and the 5-year rule for administrative dismissals is diarized properly. You can look in the program materials. LAWPRO, I think LAWPRO is a template. I don't think that's in the materials, but it should be on the Practice Pro website, probably under tools or something. But you should definitely have some kind of file progress plan for every file that you have.
And just a quick point there, and thanks, Lucas. Practice Pro does have a file progress plan, and it's in the links from today's session. So you can definitely use that as a starting point, or work one up for yourself. But certainly, definitely a must-have resource these days. Thanks.
All right. So the next tip is on file transfers, and I wasn't sure in reviewing this material. Wasn't sure in reviewing this whether file transfers applied as between internal within firms or between firms, but in both cases, I'll give the same advice. And bearing in mind that I'm in a room with paralegal students, it's not uncommon that files will be worked up by a junior member or a paralegal or even a staff member on whom we rely, and would do those initial client intakes. In fact, I'm going to suggest that most initial client intakes now, especially in the employment world, are being done by clerks, paralegals, staff. And in that respect, a lot of trust is placed on those individuals to get the dates right, to get the investigation correct. And so when the file gets handed off, one of the most important things is how much time do we have to start a claim? And remarkably, people will sit on things for way too long, to tell you. Right? I got fired when? 2 years ago. 2 years ago, like today? No, 2 years ago tomorrow. Crap, we got to get going on this. So on that, back when paper files were a thing, used to be a big red sticker on the front of the paper file that had the limitation date on it, right? Limitation date is X. Even now in electronic world, it is one of the most important things to highlight is by when must we do something, so that the person receiving the file can put that in their own system. Lawyers are notoriously bad, I'm going to suggest, at embracing shared technology. We're excellent silos, and maybe I'll speak for myself, but ensuring that whatever system the individual is using is where the data is important. And so on the handoff, it is critical that the individual who will be responsible for taking action knows the date, understands how those dates were arrived at, has that information, etc. Because unfortunately, otherwise, and for paralegals, they may be the ones on the receiving end of the negligence claim, because things tend to roll downhill. And I'm not just from practice, from my own experience, but as an employment lawyer, I see individuals who have problems at work, and problems tend to roll downhill where they can. So everyone needs to be mindful of their responsibility in their workup, especially junior lawyers, etc., when handing that information off, that it's accurate and traceable, so that dates don't get missed and that they're properly diarized in the appropriate system.
So I'm on for the next tip. I want to just alert everybody on the panel to be aware of Regulation 1822. It has a number of changes to the rules of civil procedure. I don't have time to go through them all today, but I alert you to it and make sure that you go out and grab a copy and read it. One of the biggest changes we noted in that regulation was with respect to experts reports under Rule 5303. This regulation came into effect on March 31st of 2022. It pertains to expert reports and addresses the late filing of expert reports. The new rule provides that leave may be granted. The old rule provided that leave shall be granted. There was a recent case that was heard on this matter. It's AGA versus Monroe. 2022, Ontario Superior Court 2508, where Justice Edwards said the following. I just want to read it so that you get awareness of how strict this rule will be implemented. His Honor said, lawyers and litigants need to adapt to the new rule immediately. The late delivery of expert reports simply will not be rubber stamped. So I want to make sure that you're just aware of this quick tip that I've seen, that the courts are having a stringent approach to granting procedural delays, especially if counsel ignore directions from courts or new rules. We're finding the courts are backlogged and they're just not amendable to allowing counsel to take those steps anymore. So please be aware. I know we're short for time, so I don't want to speak too much more, but I'd alert you to things like, just very quickly, criminal lawyers stream A with impaired cases. We're seeing a lot of errors on those. I want to make sure that you just double check appeal dates. You may be specialized and confident, but I always say if you're confident, it doesn't hurt to just verify the dates. So I'll turn it over to Judah now.
All right. Well, we've gone through a lot, and I think Jordan had one extra tip for us as well, and this one's a pretty important one, frankly.
Yeah. So the last tip I have is don't take on more work than you can handle. And I think it's probably self-explanatory that lawyers who are overwhelmed and have too much work are more likely to make an error, and those errors can certainly include missing limitation periods. If you're finding that your workload is too high, then as hard as it is to do, you do need to consider turning down some retainers. Also, if you've got a junior lawyer or more than one junior lawyer working under your supervision, it really is important to be alert to what their file load is and to ensure that they are not being overwhelmed. We unfortunately occasionally see situations where junior lawyers report many claims all in a short period of time, seemingly because they've been absolutely overwhelmed with very high file loads. These are really kind of unfortunate situations where the junior lawyers often feel like that they simply had no choice, that they couldn't turn down the files. I should note that in those situations, there can be issues as to who is responsible from LAWPRO's perspective for the claim, and therefore for the deductible and the premium impact, as between the junior lawyer and the more senior lawyer who was pushing the claims down onto the junior lawyer. So you don't want to be in that position. Please make sure that you don't kill your junior lawyers with enormous numbers of files.
Thanks, Jordan. I think that's a really important takeaway right now is, we always talk about time management and how we make it all happen. And subtraction is one of those keys, right? Less is more when it comes to doing good work on these files. File volume is always something that everyone in a law firm, lawyers, paralegals, clerks, all need to be mindful of. So, those are some of the key takeaways to help us manage our deadlines, to help keep our files moving, to help us reduce our anxiety around some of the bigger issues that all advocates face around limitations and deadlines. So we're going to just go to our last big theme for today's program, which is around getting to our next normal and thinking about the practice management, legal technology, and some of the risks we're seeing around legal tech and technology generally, just so that we can all move from whatever this is right now to what our next normal will be. I mean, we all had our 1.0 systems in place, right? And then COVID hit. And we put something together. We scrambled, firms scrambled, individuals scrambled. I'm still scrambling, talking to you from a kitchen table. Everyone tried to figure out what their next pivot would be. But now we're going to be reopening, and some people are going to be hybrid. Some people are going to be back to offices. Some people are going to stay work from home. We're all going to figure out what our next normal is going to look like. And there's no going back to what was before times. That is for sure. We've seen it in civil. There's the introduction of case lines. There have been new judicial protocols. There have been notices to the profession about when they will be hearing remote, when they will be in person. We've seen all sorts of shifts. And so we're going to have to stretch on our competencies and build our tech competency as we go. So, part of it is people, part of it is processes, part of it is tech. Jackie, let's start with you. What's a big takeaway for you in terms of a key thing to be top of mind as we pivot to next normal?
I think for us, and we actually, our firm started virtually, which came with pros and cons. But I think it's really a lot of, because we did things so quickly, we didn't necessarily put the best systems in place. And so I think from a really good tip is to recognize that we all kind of scrambled and to be able to look back and say, okay, what is working? What is not? Are there areas that we did because we had to be quick that we need to reassess and step back? Are we meeting all of our requirements from the Law Society and for insurance and all of those things that maybe, we weren't so concerned about when we were trying to frantically, get from the office to virtual. So I think it's really taking that pause now that things are, returning to that new normal and really reassessing, what are we doing well? And, maybe what do we really need to think through now that we have a bit more time to do that?
Makes perfect sense. Lucas, what about you?
I have sort of two quick points. One is, and I don't know if this is going to be ongoing, but we certainly in litigation, we need to keep our eye on new practice directions as they come out and make sure that we read them regularly. Pre-pandemic, you could, go 10 years without any refresh of your standard practice directions, but that certainly is not the case now. And then the second is we're obviously moving, or we have moved to a large extent from paper briefs to electronic briefs. And for superior court matters, we're all using case lines now. So it's really important to understand how to use these platforms, how to work with the electronic documents. Case lines itself, it's really convenient as a platform, but it can be finicky, has a lot of weird idiosyncrasies. There are lots of training sessions available. And, if you're not comfortable with it, or if you don't have somebody in your office who is fully comfortable with the platform, you should definitely avail yourself of those training sessions.
Absolutely. And that's a key piece is we're going to need to train and collectively get through whatever our next pieces are going to look like. Sean?
Yeah, I'm going to pick up on what Lucas said. And, the old advice that I gave to people I was speaking with, get to the court as early because the courtroom that you were assigned likely has been changed on you, and you might need to be on a different floor of the building. I don't think that changes in the virtual world in terms of getting there early. It is incumbent more than ever to ensure that the documents are where they're supposed to be and are functioning the way they are. We simply cannot rely on our staff to do things correctly. I find that things go into case lines one way, and then case line digests it and it comes back out. So get there early, make sure your documents are uploaded early, and then test them. Test them before the judge is watching. It's probably the best advice I can give, because there's two ways to find out that the documents are, or two times to find out the documents aren't working. One is the day or the night before when it's just you fumbling around. The other is when Her Honor is on the bench, which is a terrible time to find out that link does not work the way you think that link works. And you have to find some ERZAC system. It's not, you got to be prepared, and you got to be prepared for it. And the only way to do it is to do it yourself in advance. There's just no substitute for it right now, because unfortunately, you can't run to a library, print it out, and hand it up. You're not in the same place. And so it needs to be there correctly, because the old fixes don't work anymore, unfortunately.
Sean, I mean, that's spot on. I mean, through the pandemic, I've been telling people to give yourselves a COVID cushion, not just about being nice to the other side if they need indulgences, but also like things are going to take you longer than they expected. And there will be, known unknowns, and then, known knowns, and you just have to be prepared for all of it, right? And now, I think that case lines cushion makes a lot of sense. And there's, everyone's trying to work through to what the next processes are going to be, and there may be some hurdles along the way. We're all going to wrinkle it out, or iron out the wrinkles over time, but give yourself a case lines cushion. Start with the training. And then, if things go a little sideways, you've got to have that cushion for your clients to make sure that they're starting on the right page. So, technology is a double-edged sword, right? And some of the tech to do an online trial, for example, it takes longer to prep than just to show up, with paper. Let's not be fooled that technology has its ups and its downs. And unfortunately, one of the downs is cyber risks. And we're going to just spend, 3 minutes talking about this because we've got a lot that we're seeing right now at LawPro. I'll categorize them as two big areas. The first is what I'd call self-owns. These are mistakes that we just make because we're human. They're avoidable, though, let's be clear. But these are the ones where we make mistakes using our day-to-day tech. So examples, misdirected emails. We've seen emails go to the wrong side. We've seen emails go to the wrong recipient. Those are privacy breaches, if not breaches of solicitor-client privilege and confidentiality. So, that's one key area where you need to be careful around using the pre-populated fields on your emails. Lost thumb drives often contain privileged confidential information. If it's not encrypted, that's a problem. We've seen lawyers lose laptops, they leave them behind, or there's a smash and grab. That's a real issue as well. Privacy breaches should all be reported to LawPro. And so anything from an errant email through to somebody stole my computer ought to be reported to us, and we'll help you navigate through next steps. The others are that we're targeted. Lawyers are targeted, not just because we have email addresses. Yes, like anyone else, we get those spammy type things, but we're also being targeted because we have trust accounts and because we are professionals. And so we have seen recently law firms being targeted through their internal systems for ransomware and for bad check frauds that are now taking place by wire transfer misdirection, where somebody is sending you an email with wire information to send money out of trust. And so we are seeing all sorts of ways where people are either mimicking passwords, mimicking emails that look like familiar emails, or they've actually hacked into somebody's email, whether it's the lawyer on the other side, your own system, or a client, and they're sitting on a transaction and then emailing from a legitimate site and then asking for funds. And it looks like it's coming from the proper people. Regardless of how these requests for money are coming in, you need to call before you click. Call across using a number you know is genuine by checking on their website or because you have them in your contacts already before any money goes out. It's really important that we do that. And Lucas, you've seen some really sophisticated issues around here. Do you want to just share one example quickly so people get a sense of this?
Yeah, I mean, there was an incident happened over the last year, and I'm acting for a company that is involved in, the matter involves several actions by a municipality against about 100 companies and individuals, most of whom have no connection with each other. There's a lengthy service list, and emails are sent by counsel on a regular basis to the list, some attaching letters and other documents. And the norm today is if you got a lot of documents, you'll have a OneDrive link or some kind of link to download those documents. It looks like somebody got one of these email threads and sent an email to the service list, and it's actually pretty sophisticated. The person is pretending to be counsel for one of the parties and actually includes a link to download certain documents. But what makes it so sophisticated is that the email is almost exactly on point, is what you would expect from an email sent by one of the parties or one of the counsel. It actually refers to the plaintiff by name and has context-specific content in the email. And if you scroll down into the email, it's a lengthy thread of tons of legitimate emails. It's probably an email from me at some point. Now, I actually clicked on the link. And fortunately, all of my firm's cybersecurity protections went off and stopped anything bad from happening. And then within a couple of minutes, I got a call from our IT manager, who was yelling at me for being an idiot and demanding that I shut down my computer and come to the office. And it was very, very inconvenient. But, I work for a fairly big firm, and not every firm's going to have those types of protections. And, you just never know. So it's just about being extra careful. Because some of these attempts are becoming extremely sophisticated.
I was really struck by how sophisticated that scheme was. And we've seen this. We've seen what we describe as, the call coming from inside the house sort of scenario, those horror scenarios where it's an internal breach that's then being used to extract money. And so these are really important for lawyers and paralegals and law firms to know, because they happen, you're being targeted, and there is limited coverage depending on the situation. If you were just hacked, your professional liability insurance may not be the full answer to that. It may not be an answer at all. There are other coverages that you might need, but it starts with education and training. And so to start with that, to fill that gap, we developed a program in December about avoiding the wire fraud nightmare. It's on practicepro.ca/CPD. It's available, it's free, it is accredited for CPD. And we know some firms, all staff watched it, and we know that it's already helped some avoid several $100,000 of going out of trust through one of these diversions that came in during the same week that we ran the program for all of the professions. So we encourage you to watch it and have your staff watch it as well, because firms are only as strong as the weakest tech-trained person when it comes to passwords and hygiene and all of that. So we get into all of that at our December program, and we encourage you to watch it. We also want to encourage you to join us again. We've sort of come to the end of today's program, but we've got another one coming up with the Toronto Lawyers Association on June 9th. It's Tips for Wills and Estates Lawyers. It's free to register, so visit the TLA's website to join. Just a few housekeeping matters. First, thank yous. Thank you to you, all of you who took the time today to join us live. Thank you if you're joining us on a replay. Thank you to the Toronto Lawyers Association, to Joan, Deirdre, and the entire TLA team, Sandra, everyone. Thank you for being such lovely partners and for helping to amplify this important information to get to the professions. Thanks to Ontario's law associations who have continued to promote these events. Thank you for all of our speakers for sharing your expertise with us. We're really grateful. And you can help us. You're going to be receiving an email from the Toronto Lawyers Association for a program evaluation. Please complete it. It'll help both TLA and LAWPRO develop timely programming for going forward. I have a mea culpa for today. There were lots of questions flying through. We couldn't get to all of them. If you had one and we didn't get it and you'd like to speak further about it, just email us at practicepro@lawpro.ca and I or one of my colleagues will respond. Just wanted to remind everyone that today's program is eligible for 1.5 hours of professionalism credit and for LawPro's risk management credit, which can be claimed at lawpro.ca. This program is also going to be available as a replay on practicepro.ca's CPD webpage. And if you want to be the first to know when it goes live, you can subscribe to our avoidaclaim.com blog. And when we post on our blog that the event is available, you'll receive an email direct to your inbox to let you know. So that concludes our program for today. Thank you again for joining us. Be safe. Take care.